Analenka. WhatsApp audio.
Good afternoon. This is Dr. Olu Asekun again. Welcome to my podcast. This podcast is we'll be repeating it every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. Here, viewers will have the opportunity to ask immigration questions free of charge. We'll be doing this every week. Today, we are going to be discussing questions relating to adjustment of status. Questions relating to adjustment of status. So, while we are giving the overview, if you have questions relating to adjustment of status, you can send them in. Welcome again. Welcome again to our podcast. This is Dr. Olu Asekun here. Today, we'll be discussing adjustment of status, especially family-based adjustment of status. Next week, by God's grace, we'll be discussing employment-based adjustment of status. So for this week, we are discussing family-based adjustment of status. This is Dr. Olu Asekun here. This program will be repeating it every Wednesday, 12 p.m. Central Standard Time, by God's grace. Welcome to our podcast. So you can start sending your questions in. Usually, adjustment of status, when we are talking about family-based, it means that a U.S. citizen can petition for family members. A U.S. citizen can petition for family members. And the way immigration law defines family is different from the way English dictionary defines family. So that's very important, very, very important. For immigration purpose, The family of a U.S. citizen includes the parents, the spouses, that is husband and or wife, and minor children under 21. So your own biological child or children who are 21 years old, for immigration purpose, they are not defined as your family. I know under English dictionary that would be family, but for immigration purpose, here in the United States, they are not considered part of your family. They are considered extended family. They are not considered your immediate family. So for immigration purpose, immediate family of a U.S. citizen only includes the parents, the spouses, and minor children under 21. Anything out of that is considered extended family. So your children who are 21 years and above are considered extended family. Your siblings are considered extended family. So it is very, very important to understand that. That does not mean that a U.S. citizen cannot petition for extended family member. What it does mean is that there are limitations, and for timing purpose, immediate family gets priority over extended family. That is for processing purpose. In addition, immediate family, they do not have limit. There is no numerical limit to the number of applications that immigration can approve yearly, unlike extended family members. For extended family members, there are limits to the number of green cards that immigration can approve annually. So those are some of the major differences. For example, if a U.S. citizen is petitioning for siblings, the waiting time as of today is about 13 to 15 years before they get to it, because those kind of petitions are not given priority. Unlike immediate family, if a U.S. citizen is petitioning for parents, if that parent is here in the United States and entered the United States legally, it does not matter whether they are in status or not, that kind of application can be approved within 6 months. So you can see the difference between immediate family and extended family. For some extended family, the waiting period may be between 5 years and 15 years. Whereas for immediate family, just like the word immediate, it means it can be approved immediately. That is what it simply means. So there's a lot of privileges for U.S. citizen petitioning for immediate family. Another important thing that I need to point out when it comes to applying for waivers, especially when somebody has been found inadmissible for any reason and the person requires a waiver, immediate family members are usually what we call qualifying relative. In other words, you can get a waiver approved if you have immediate family member. That is, you must have someone who is either a U.S. citizen or a legal permanent resident, who is either your parent, your spouse, or minor children. Those are requirements or conditions for getting a waiver approved. So while we are going through this, I want to encourage you to send in your questions. So if you have questions, send in your questions. Today we are dealing with adjustment of status based on family-based adjustment of status. So if you have questions, send in your question. We'll be repeating this process, this podcast, every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. Advert, short one. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, It's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through in it. Like I mentioned, like we all handle their case, we all know their cases. And it's like I am one of them and I understand what's going on. And I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family.
Welcome back. This is Dr. Olu Asekun again. Welcome to our live podcast. We'll be doing this every Wednesday, 12 p.m. Dallas time, that is Central Standard Time. So today, we are discussing family-based adjustment of status. So I've been explaining what family-based adjustment of status is all about. And right now, questions are starting to come in. We've received a couple of questions. I'm going to read them and try to answer them. The first question we received is, My ex-wife is a U.S. citizen. She got a green card based on marriage to another man, but they are divorced. We got back together recently. We have 2 children together and want to remarry. Can she petition for me? Will immigration allow that, or will it be a problem? Well, this is not a yes or no question. The answer to this question is not a yes or no answer. One thing I always say when it comes to immigration, immigration is not a one-cap-fits-all. It's not something that it's not like mathematics where you say 2 plus 2 or 2 times 2, you get 4. Immigration is not like that. Every single case is different. So we have to look at the specific circumstances of your case. But generally, I will tell you that if you were previously married and you and your husband were divorced, your husband married a U.S. citizen, obtained green card, and subsequently remarried you, or you plan to remarry you, what I will tell you is that will generate what we call red flag. That will create a red flag. Red flag does not mean denial. It doesn't mean that your case is going to be denied, but it simply means that immigration will look closely into the marriage with the American citizen and be sure that this was not a marriage of convenience. They will have to determine that this was not a marriage based on fraud. Immigration law. Under immigration law, there are 3 situations under which nobody can get green card. Section 204C of the immigration law says that no petition shall be approved where immigration has made a determination that someone entered into a marriage for the purpose of evading the immigration laws. So what that means is that if immigration finds out that your marriage is fake, you married someone just for the purpose of getting green card, if they made that determination, such a person, there is no other petition that could be approved for you. So even if you marry American president after that, except the Congress change the law, you cannot get green card approved. So it is very, very important to understand all this. So I'm not saying that it is not possible for someone who is previously married to another person to have to come back and remarry. No, it is possible. But what I'm saying is that if that happened, the previous marriage will be looked into. Immigration is going to scrutinize that previous marriage, the marriage with the American citizen. They are going to scrutinize it and be sure that it was a valid marriage. So if that marriage passed the test, then there will be no problem. But if that marriage failed the test, not only will it be a problem for you, but even your ex-husband may also lose his green card if that determination is made that the marriage was. Immigration will look into that marriage and be sure that it was not a fraudulent marriage entered into solely for the purpose of evading immigration laws. Keep your questions coming. Before I go into the next question, let me continue what I was trying to explain earlier. Under 3 circumstances, no petition could be approved for someone who has been determined to have entered into fraudulent immigration and fraudulent marriage. That is the first one. That is the first thing that can prevent somebody from getting a green card in the United States. The second thing that can prevent someone from getting a green card is if somebody file what we call frivolous asylum application. Now, the fact that you apply for asylum and it was denied does not mean that your application is frivolous. Frivolous simply means fabrication, something that didn't happen, something that was fabricated, story that was fabricated. So if immigration makes that determination that your story was fabricated, it was something that did not happen, if they make that determination, such a person again it will lead to permanent bar. So such a person cannot get any immigration benefit. So it doesn't matter who you marry. If you marry American president, you will still not be able to get green card in the US, except the Congress change the law. That is the way the law is as at right now. The third thing that can prevent someone from getting green card is crime, especially aggravated felony offense. If someone is convicted of aggravated felony offense, the person may not be able to get green card. And in fact, if you already have green card, you may lose it. So those three things prevent someone from getting green card. So marriage fraud is a very, very important factor in this scheme of things. So it is something that is extremely delicate, and I will advise you, if you are contemplating remarrying your husband, I will advise you to seek advice from an experienced immigration attorney who can look into your specific case and then advise you appropriately. So keep your questions coming. Keep your questions coming. So today we are discussing family-based adjustment of status. So talking about family-based, I've explained earlier what immediate family is. To a U.S. citizen, for immigration purpose, immediate family means parent of a U.S. citizen, spouse of a U.S. citizen, minor children of a U.S. citizen. Minor mean children under 21 years old, not 18, under 21 years. 18 years have its own implication. There are some areas where age 18 matters. But for the purpose of determining whether someone is immediate family or extended family, the cutoff age is 21. It is 21, not 18. 18, however, is relevant if the petitioner is going to file the petition based on step-parent status. For example, if someone who already have children is getting married to a U.S. citizen, if that U.S. citizen is going to petition for those children must be under 18 at the time of marriage. They must be under 18 at the time of marriage. That is where 18 years cutoff is relevant. But for the purpose of determining immediate family, the cutoff age is 21. Again, depending on the peculiar situation, even when a child turns 21, such a child or children may still be protected under what is called Child Status Protection Act, CSPA. I think there are more questions. Keep the questions coming. Okay, we receive another question. My parents don't know I'm married. Can immigration contact them about my case? My husband is a citizen and filing for me. I'm very concerned that everyone will find out and I will get into trouble. I'm trying to see what exactly is the question here. My parents don't know I'm married. Can immigration contact them about my case? My husband is a citizen and filing for me. I'm very concerned that everyone will find out and I will get into trouble. Well, my understanding of this question is that you want to know whether you can be married and your U.S. citizen petition for you without anybody finding out. The way I'm going to respond to the question is this. As I said in answering the previous question, marriage fraud is something that triggers permanent bar under Section 204C of the immigration law. So, whether your parents are aware or not is not the determining factor. The determining factor is whether your marriage is legitimate or not. Your parents may be aware and your marriage may be fake. Your parents may not be aware and your marriage may be legit. So it is not the awareness that determines whether you get into trouble or not. It is the legitimacy of the marriage that determines whether you get into trouble. So what I'm saying in essence is that if your marriage is legit, if you are married for real, if this was not about immigration, whether your parent is aware or not, if you provide sufficient documentation about your marriage, immigration can approve it without contacting your parent or even contacting anyone. However, if you filed, if your husband petitioned for you and any of the petition or any of the documentation triggers what we call red flag. Now, red flag does not mean denial. Red flag simply means look more closely, investigate further. Something is not right. That is what red flag means. So if your case raises red flag, definitely that will trigger investigation. And whenever investigation is triggered, of course, it is possible that immigration can contact your parents. It is possible that immigration can contact your neighbors. It is possible that immigration can contact your siblings. I mean, once investigation is triggered, the manner of investigation is open-ended. They could contact your landlord. They could contact your employer. They could contact your parents. They could contact your siblings. They could contact your neighbors. They could use public record to determine your activities, to determine where you live, to determine whether you live together with a U.S. citizen or not. So there are a lot of things that they could do once investigation has been triggered. So the most important thing here is not about your parents knowing. It is more about whether the marriage is real or not. If the marriage is not real and it triggers investigation, it could lead to permanent bar under Section 204C. And of course, that will get you into trouble if that is what you are trying to avoid. There's another question here. Can I call in through the WhatsApp to present my case? It's a bit lengthy. Yes, you can call us at 817-983-4499. You can call us on WhatsApp 817-983-4499. While waiting for the call, there's another question. My wife is a U.S. citizen and she's filing for me. And my children, my firstborn, is a bit above 18 before our marriage. And someone said the minimum age has been adjusted to 21 by immigration law. Alpha. Well, whoever said this to you lacks knowledge. This is one of the side talks or side street information that leads people to trouble. The law has not changed. The law has remained constant. And that is why I explained the difference between the age 18, what age 18 does and what age 21 does. For the purpose of step parents petitioning for someone, the cutoff age is 18. The child must be under 18 at the time of marriage. That is the law and it has not changed. If anyone is telling you anything to the contrary, they are not being honest with you.
Hello. Hello, good afternoon, sir.
Okay, I think we have someone on the line.
Yes. Yes, sir. Hello?
Go ahead.
Hello?
Go ahead with,
Hello?
with your
Okay,
question.
all right.
You are
Thank you, sir.
live. We can hear you.
Yes. My question is this, sir. My wife, we are Nigerians. So 3 years ago, going to 4 years now, by May, it will be 4 years.
Go ahead.
She went to the US with our children. The purpose of the traveling then was vacation. So when she got to the US, barely a month after she got in, she cut me off.
Hello?
I was unable to get in
You are
touch with her.
breaking up. Can you
Hello?
start the question again?
All right. I said, my wife, we are Nigerians. My wife and my children, they traveled to the US in 2019, May. Now, when she got to the US with the children, barely a month, she cut me off. Hello?
Hello? Okay, I think we have it on speaker.
Okay, can you hear me now, sir?
Yeah, go ahead.
Okay, so by the time she got to the US, barely a month.
No, can you start from the beginning? Because I missed most of the question.
All right. I'm a Nigerian. Then my wife traveled to the United States in 2019 May. So barely a month she got to the US, she cut me off. So I was unable to get in touch with her and the children. So late last year, I got to know she had issue with the CPS. They took the custody of the children from her. Now, when the CPS and the court were asking about the presence of the father, she now told them that we are divorced. Meanwhile, we did not do anything like divorce, to the best of my knowledge. Now, later when she was trying to get the kids from the CPS because they evaluate her for psychiatric issue. So, they were not telling her that she should present the father. So later, she got in touch with me. Then I was in touch with the CPS. Now, when I now asked the CPS what happened, they sent me the details of what happened. They now made me realize that she has been making every attempt that if the children cannot be returned to her in the US, that the children should be sent back to her parents in Nigeria without my knowledge. So when I got to know about that, I don't want the idea of the children being returned to Nigeria. So I told them that Nigeria is not suitable for them at the moment, educationally and safety-wise. So they now suggested that if we have any family member in the United States, they can give the children to the family member so that the children can continue their school. Now, I now requested from the court that I would like to pay the children visits. They now said, okay, anytime I'm ready to come to the US, I should let them know so that they can get me a court document that will back that up. Now, the issue I'm now having is, I got to know she filed for divorce as soon as she got to the US without my knowledge. Now, if I want to apply now, I know there will be a session that will ask me if I'm divorced or not. I don't know how to go about this, and I don't want it to jeopardize my chance of being considered or being given visa so as to see my children and gain their custody back. So that's why I call, sir.
Like you said, this is a very lengthy story. But yes. I'm trying to know what exactly is your question. What question are you trying to find out?
Now, the question I have is because I know at the immigration, like if I'm applying, they will ask me if I'm divorced or married. The best of my knowledge is we are married. When she got to the US, she filed for a divorce in Nigeria without my knowledge. I didn't know anything about it. So when all these issues happened, I asked the CPS what happened. They sent me the reports. When they were asking that question, she said we are divorced. And I'm not aware of that. Now they give me the opportunity that if I want to come and attend the court case and gain the custody of my children, I can come. Now, if I want to fill my form for coming to the US, the section where they will ask me if I'm married or divorced, what is advisable for me to put there?
Okay, let me ask you a couple of questions. You said you contacted the CPS. In what state is that?
In Texas.
Okay, in Texas. Okay.
Yes.
Do you know what county? I mean, if you contacted CPS, they will give you information about the county where the
It's Rosenborg. I know the county because they do send me the reports. The county is there too. When I check my phone, I can bring it out.
Okay, what I'm going to advise you is the first thing you need to do is to find out through the county, find out from the court the divorce document. If she was divorced, I mean, divorce is a public information here in the US. So if you contact the court, if you know the county, you can search the county record and you can make a determination, you can obtain a copy of the divorce document. So if you have the divorce document, not only will you be able to determine the status of your marriage, but you will also have information about the custody of the children. So
Now, the custody of the children is actually with the CPS, but she identified a family member over there. So they took the children to the family member.
I understand that. What I'm saying is, if you get a copy of the divorce document, it will give you more information. And the only way to get that, if not through her, will be through the court.
Okay, because she sent me the copy of the divorce. And
If you already have a copy of the divorce, then why are you asking this question?
Now, why I'm asking this question is because the condition she gave for the divorce, she put us all there, and we've never fought throughout. So
that's not relevant to your question. Your question was whether to indicate in your visa application that you are married or not.
Hello?
If you already have a divorce document, then why are you asking that kind of question?
I want to know, because I don't want a situation whereby I will not know the right thing to feel in the form.
But you already have the right thing. You have a divorce document in your hand. You have a final decree of divorce. So if you indicate that you are married, then it means that you lied. If you already have divorce document, what is the issue here?
She did the divorce document in 2019. She just sent it to me last month.
It does not matter. What matters is to answer your question, you want to know whether in completing your form, whether you should state that you are married or you are single. You already have a divorce document in your hand. You are divorced. It's as simple as that. Even if you are coming to contest the divorce, that does not change the fact that you are divorced.
Okay, sir.
Once a competent court has pronounced that your marriage is dissolved, it means that you are divorced.
Okay. Thank you very much, sir. That's what I want to know.
Not a problem.
So as not to put myself into trouble while filling the form. Thank you very much, sir. Thank you.
You're welcome.
All right.
Keep your questions coming.
It was no longer like, okay, this is a client, this is somebody it's providing you service, right? So it became something like a family. So I can see the relationship was good working with his staff. People give me encouragement, but I will look at it and say, how is it possible? I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But he knew what he was doing. Like I said, research is very, very important. If you do research, you will learn a lot of stuff. There are a lot of immigration rules some people don't look at. There are loopholes there, and sometimes they purposely put them there. So it's research, and it's using those research to help a lot of people. Not just me. It is not just me. It is a lot of people here many people here that he has helped. Many people. Sometimes it doesn't even charge them. When it comes to the point that it doesn't even charge them. So yes, if you are looking for immigration lawyer, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know any immigration lawyer? I won't even blink, I will say it, Dr. Asekun is there, I will just say it. So, that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. You know, he's the best immigration lawyer you can have.
Welcome back. Welcome back. Let's see if we have other questions. Yeah, I think there are other questions. Welcome back. This is Dr. Olu Asekun's podcast. We do this every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. You are welcome to invite your family, friends. It's free of charge. We answer all immigration questions. But today, we are discussing family-based adjustment of status. Family-based adjustment of status. If you want to call in, you can also call in. Our number is 817-983-4499. You can call in on WhatsApp. You can also call in on direct line. Our next question. I have an application pending with USCIS. I smoke marijuana every day, usually after work. It's not legal where I live. That is Texas. Could this have a negative impact on my case? I have never been arrested or charged with anything, but our interview is coming up, and I know I have to get the medical exam. Will it come up and hurt my case? Well, this is a very good question, but unfortunately, it's not a question that I can answer. This is a question for medical professional. The only thing I will say is that if someone is convicted of drug-related offenses, yes, that will be a problem. That will be problematic. If someone is convicted of immigration-related offenses, if someone is convicted of drug-related offenses, yes, that would be problematic. But in your case, since you said you have not been convicted, you have not been arrested, so I don't see any problem right now. But the challenge here, which is why I cannot answer the question, I'm not a medical personnel. I don't know for sure if your drug use will show up in your test. It's only a medical doctor who conduct the test that can make that determination. So it's not something it's not a determination I can make. However, if you have been arrested or convicted of drug-related crime, yes, that will have a serious consequence on your application. But with the facts of this question, I don't see any problem here except your drug use shows up in your medical examination, and that is not something I can determine. That will have to be by the medical doctor. And even if it comes up, honestly, I don't know. I don't know whether it will come up or not, because to the best of my knowledge, the only time drug use could be a problem is if someone is convicted of drug-related offenses, then it becomes a problem. Keep the questions coming. Keep the questions coming. Today we are discussing family-based adjustment of status. Keep the questions coming. Let's take a short break while expecting additional questions.
I was looking for Lawyer Shekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Lawyer Asekun is the best lawyer so far in Texas because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he's the best lawyer. So far, so good.
Our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury. Okay, welcome back. Today, we are discussing family-based adjustment of status. So keep your questions coming. Family-based adjustment of status. This live podcast is every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. So today we are discussing family-based adjustment of status. So keep your questions coming. Next week, by God's grace, we'll be discussing employment-based adjustment of status. So today is family-based adjustment of status. So keep questions coming. I think there's a question. Let's see. Okay. There's a new question here. My son is turning 21 in 6 months. I entered the U.S. illegally once and stayed. My son is a U.S. citizen. Is it still possible for me to get a green card? This question is a little ambiguous because when you say you entered the U.S. illegally once, I don't understand whether this means you entered the U.S. without a visa or you entered the U.S. with a visa and then overstay. Now, I'm going to answer the question both ways. If you enter the U.S. with a visa and subsequently overstay, if they give you 6 months at the port of entry and you overstay your 6 months, it doesn't matter how long you overstay. If your son is a U.S. citizen and is 21 years old, yes, he can petition for you and fix your status. It does not matter how long you have been out of status. However, there is one caveat. There is still a major requirement. You have to show that since you have been here, you have never falsely claimed to be a U.S. citizen. You have never falsely claimed to be a U.S. citizen. If you have not done that, yes, your son can file for you, can petition for you, and you still get your green card. It doesn't matter how long you have been here illegally. It doesn't matter whether you have worked unlawfully. All that will be waived. You don't need to even file a waiver. It will be waived by operation of law. As soon as your son turns 21, yes, he can petition for you. Now, on the other hand, because the question says, I entered the U.S. illegally. So if what you mean is that you entered the U.S. without a visa, maybe you're walking through the border or you walking through Mexico or Canada or any U.S. Neighboring countries, even if your son turns 21, he will not be able to fix your status. You will not be able to get green card if you entered illegally. The law requires that anyone applying for a green card in the U.S. must enter the U.S. legally. Now, entering legally and overstaying, they are two completely things. So if you enter the U.S. with a visa and you are inspected at the port of entry, whether you drove in or you flew in or you came in through any other means, for as long as you enter with a valid visa and you are inspected at the port of entry and you are admitted into the U.S., that is the only thing that is required. As soon as your son turns 21, he can petition for you for as long as you have never claimed to be a U.S. citizen. You have never falsely claim to be a U.S. citizen, yes, your son can fix your status. But if you enter the U.S. without a visa, if you walk in illegally without a visa, if you walk in through the border and you are not paroled, then your son turning 21 or being a U.S. citizen will not fix your status. Even I can tell you authoritatively that there is no waiver available for that category. The only thing for those who have immigrant visa filed on their behalf before April 38, 2001, you can apply for adjustment of status under Section 245I. You will have to prove that that immigrant petition that was filed prior to April 30, 2001, that immigrant petition was approvable when it was filed. If you meet that requirement, you will pay a penalty of $1,000 in addition to all the necessary filing fees, and then you can adjust your status. But if no such petition was filed on your behalf, you are not eligible for adjustment of status, and there is no waiver available for your category. Keep the questions coming. Keep the questions coming. Today we are discussing family-based adjustment of status. Keep the questions coming. While waiting for more questions, I want to say that for the question I just answered, if it were the other way around, if the child of a U.S. citizen or someone who is married to a U.S. citizen is the one that entered the U.S. unlawfully or illegally without a visa, we may still be able to fix that, because such a person can still apply for what is called unlawful presence waiver. So what that means is that the person will not be able to apply for green card while in the U.S. The person will be able to apply for unlawful presence waiver. And then when that waiver is granted, the person will have to process what we call, the person will have to do what we call consular processing. The person will still need to go back to his or her home country, but will go with an approved waiver, which means that that unlawful presence has been waived, and the person will be able to apply for green card through the embassy and still get the green card. So that is if the petitioner is the parent, not the other way around. In this case, the petitioner is the child. The illegal entrant is the parent. That waiver is not available in that situation. So I hope that question is my answer is very clear on that. So keep the questions coming. Keep the questions coming. We are willing to answer all questions you may have today on family-based adjustment of status. Next week, by God's grace, we'll be discussing employment-based adjustment of status. So if you have questions regarding employment-based adjustment of status, keep them till next week. Today, we are discussing family-based adjustment of status. This program is every Wednesday, 12 p.m. Central Standard Time. So we are willing to answer all your immigration questions free of charge. So you can text your questions. You can also call in. If you want to call in, you can call us on WhatsApp on 817-983-4499. 817-983-4499. You can also send in your question through this live chat. You can also send in your question through the same number on WhatsApp. Okay, we have a new question that just came in. I have a question. Does USCIS treat same-sex couple differently? No. The answer is no. At least, we need to understand that immigration law is not covered by state law. Immigration law is federal. It is governed by federal law. And as at today in the United States, the federal law position is that same-sex marriage is valid. So, same-sex couple can file a petition for each other. So there is no separate standard. But just like the way a normal heterosexual relationship sometimes gets scrutinized, of course, same-sex marriage too can be scrutinized. But let me say this, because we have represented clients in this office who are same-sex, and of course, the green cards were approved. But what I want to tell you, it is dangerous to fake same-sex, because just like English language or like any other language, I want to tell you that same-sex relationships, same-sex people, they have their own language. They have means of communicating. They have, it's like someone who uses sign language. If you don't understand sign language, you will just notice that they are making gestures. You will not understand what they are saying. So same-sex people, they do have their own language. So if you are not a same-sex person and you fake it, if you are unfortunate and you get an officer who happens to be same-sex, and then they throw in a couple of things using their language and you have no idea what they are talking about, then you get into a serious trouble, because they will find out that you are not one of them. So it is not advisable at all to fake it. But if you are a real same-sex couple, yes, you are not treated differently. They don't treat them differently. Immigration law is governed by federal law. And so federal law makes same-sex marriage legal. And immigration does not have a choice other than to comply with the law. So they don't treat them differently. Now, another question. My partner wants to file for my green card. I'm scared because I've heard that immigration is harsh on gay couples and that they don't approve. Again, I just answered this question. This is not true. This is not true. In this office, we have represented a lot of gay couples and their green card were all approved. In fact, we don't even have a single denier in this office when it comes to representing gay couples. We've had 100%. So that is not true. Your case can be approved for as long as you are legitimately gay, not fake one. If you are a fake one, you can get into trouble. So do not say I didn't tell you. Now, another question. Okay, still the same question on gay. Do they scrutinize gay couples? Yes, they scrutinize gay couple the same way they scrutinize real couple. Usually, you have to understand that when you submit a petition on behalf of a spouse, USCIS or the government or immigration, they don't know you. They don't have a way of determining whether your marriage is legit or whether your marriage is one of those fake marriages entered into solely for the purpose of getting green card. They don't know all these things. So they are no magician. How are they going to know if your marriage is real or not? They can only find out by conducting interviews, by looking at the documentations that you submit, and by conducting investigation if necessary. So they have to scrutinize it to find out if this is real. Otherwise, if they don't scrutinize, then it means people will continue to do fake marriages and they will continue to enter into fraudulent marriages. So yes, every marriage-based petitions are scrutinized. Every marriage-based petitions are scrutinized, just like every employment-based petitions are scrutinized. In fact, every petition Every petition, it doesn't matter how, whatever it is based. Even if you are a millionaire and you apply for a green card based on your investment, they are still going to scrutinize it. They have to be sure that you obtain your money, your fund legally. So every kind of petition is scrutinized. I'm not aware of any petition that you file that will not be scrutinized. Even religious leaders, even churches, when they submit petition, they get scrutinized. In fact, immigration even for religious petitions, immigration even conducts site inspections. They have to visit the religious organization and verify that everything they stated in the application or petition is true. So every single petition is scrutinized. So that is not something that is unique to gay couple or anything. No, every petition has to be reviewed and scrutinized, and they have to be sure that the applicant is eligible for the benefit they are seeking. It is one of the requirements before any petition is approved. Even those who won the visa lottery, even if you won visa lottery, they still scrutinize you. They want to be sure that you are not a terrorist. They want to be sure you are not a criminal. There's no petition that you file that will not be scrutinized. Every single application, every single petition is scrutinized in order to ensure that the benefit being sought is given to the applicants who are eligible for it, and in order to prevent fraud. Keep your questions coming. Today we are discussing family-based adjustment of status. So keep your questions coming. We are discussing family-based adjustment of status today. So keep your questions coming. Keep your questions coming. I think somebody wrote a question and then deleted it. Okay. Keep your questions coming. We are still here waiting. Keep your questions coming. Today we are discussing family-based adjustment of status. This program will be every Wednesday, 12 p.m. Dallas time. That is Central Standard Time, every Wednesday. You can join us on YouTube, and you can subscribe so that when we go live, you get the alert. You can also do the same on our Facebook page so that when we go live, you get our alert. Today, we are discussing family-based adjustment of status. And next week, by God's grace, we'll be discussing employment-based adjustment of status. So, keep your questions coming. Keep your questions coming. Keep your questions coming. Keep your questions coming. We are discussing family-based adjustment of status today. Keep your questions coming. Keep your questions coming. We are discussing family-based adjustment of status today. Keep the questions coming. You can also call in. You can call in, call our number on WhatsApp. The number to call is 817-983-4499. Yeah, somebody just asked, what is the number to call? Yes, you can call in on WhatsApp, 817-983-4499. 817-983-4499. You can also send in your question through WhatsApp. You can also send your question live on this podcast. You can send in your question. Today, we are discussing family-based adjustment of status. We are discussing family-based adjustment of status. Keep the questions coming. Today we are discussing family-based adjustment of status. So all questions regarding adjustment of status based on family relationship, keep them coming today. Keep your questions coming. You can also call in. Call us on WhatsApp, 817-983-4499. Call in to ask your questions. Today we are discussing family-based adjustment of status. Okay, I think we just received another question. I just married a green card holder. I'm in the country legally on a current visa. Can he file for me? Yes, the answer is yes. Yes, he can file for you. Now, let me say this. There is a difference between a U.S. citizen petitioning for someone and a permanent resident petitioning for someone. One of the major differences is that a U.S. citizen can petition for someone who is already out of status. In other words, if you enter the U.S. and you are given I-94, which specify how long you are supposed to be here legally. Let's say you are authorized to be here for 6 months. Maybe you came in on a visiting visa and you are authorized to be here for 6 months. If while you are still in status, you are married to a permanent resident who filed the petition before the expiration of your status, yes, you will be able to get the green card. However, if your I-94 is already expired, your green card application is going to be denied because it is only a U.S. citizen who can petition for someone who is already out of status. Again, bear in mind, being out of status does not mean expiration of a visa. It is more of expiration of the I-94. You can have a valid visa and be out of status. And you can have an expired visa and be in legal status. So it is very important to understand the difference. Again, you can have a valid visa and be out of status. And you can also have an expired visa and be in legal status. It is not the visa that determines the legality of your status in the U.S. It is more of the I-94. So whatever period you are given at the port of entry, or if you have applied for a change of status, whatever status you are given, that is what determines whether you are legal or not. And if you are legal, yes, if you marry a permanent resident, someone with a green card, they can file a petition for you and you get your green card. But if you are out of status, even if you enter legally and you are out of status, a green card holder cannot petition for you. Only a U.S. citizen can do that. I think we have more questions. Keep your questions coming. Keep your questions coming. I just married a green card holder. I'm in the country legally on a current visa. Can he file for me? Yes, I believe we already answered that. Okay, another question. Good day, sir. Thanks for the excellent job. Does a green card allow you to live in the USA forever? Yes. The green card, it says green card actually means permanent resident. And the word permanent means forever. Yes. If you have green card, you can live in the US permanently, forever. Yes. However, you can also, if upon meeting certain requirements, you can also apply to become a US citizen if you have your green card. But if you choose not to become a US citizen, yes, you can continue to use your green card forever. Even though green card does have expiration date, but the expiration does not affect the permanent nature of your green card. The expiration date is only to give immigration opportunity to continue to remember that you are still here as a permanent resident. Let me give you an analogy. When you learn how to drive, you become a driver and you apply for a driver license. However, once you know how to drive, you can drive forever until you die. So you don't stop, you can't unlearn how to drive. You know how to drive is a one-time thing. Once you can drive, and you can drive permanently. However, if you apply for driver license does not have unlimited duration. Usually, driver licenses do have expiration date. That does not mean you can no longer drive. It simply means they want you to come back to review, to renew your driver license. They want to be sure that you are still complying with the terms and conditions of a driver. So it is the same thing with green card. You have your green card. It is usually valid for 10 years. So within 10 years, you may choose to apply for citizenship. But if you choose not to apply for citizenship, your green card is still valid. At the end of 10 years, you just apply to renew it. You are still a permanent resident. Your permanent resident status has not changed. You are still a permanent resident. You just need to apply to renew it just to tell immigration that you are still complying with the terms of the green card. So that is the whole purpose of renewing. But does it keep you here forever? Yes, it does keep you here forever. Keep the questions coming. Keep the questions coming. This program is every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. Here you have the opportunity to ask all your immigration questions free of charge. So tell your family, friends to log in every Wednesday. You can also subscribe to our channel so that when we go live, you get the alert, you get the notification that we are live and you join us. Send in your question. Today, we are discussing family-based adjustment of status. By next week, by God's grace, we'll be discussing employment-based adjustment of status. But for today, we are discussing family-based adjustment of status. So if you have questions, keep your questions coming in. You can send in your question through our chat. You can send in the question through our WhatsApp. You can also call in. You can call us in live. If you want to call live, you can call 817-983-4499. Call us on WhatsApp or regular line, 817-983-4499. You can also send in your question through WhatsApp or through live chat. Now, I think we have another question. Why do some people get a 2-year green card and why do others get the 10-year? Okay, that's a very good question. Yes, there are categories of green card. Some people get 2 years green card, while some people get 10 years green card. Usually, green card is valid for 10 years and it is renewable. However, depending on the condition upon which you apply for green card, that is what determines what kind of green card you get. If you apply based on family, if the petitioner is a child or parent, you get 10-year green card. A U.S. citizen who is petitioning for parent, the parent gets 10-year green card. They don't get 2-year green card. A U.S. citizen petitioning for children, the children get 10-year green card. They don't get 2-year green card. A U.S. citizen petitioning for children under 18 years, the children get citizenship. They don't get green card. A U.S. citizen petitioning for spouse, that is, husband or wife, if the marriage that created that relationship if that marriage is less than 2 years at the time that the green card is approved, that is when immigration give 2-year green card. That is one of the situations when someone gets a 2-year green card. The reason is this: U.S. government is aware that some people are fraudulent. They are aware that some people come into the U.S., marry American citizens for the sole purpose of getting green card. As soon as they get the green card, then they divorce the American. Now, this is not going to solve the problem, but at least it gives them some leverage. Whenever a marriage is less than 2 years, they look at it with suspicion. Okay, you are married. We are not sure whether this is legit or not. Go and live together for the next 2 years with this green card so that at least you'll be able to work, you'll be able to travel, you'll be able to do whatever you are required to do. And then come back in 2 years to show us that your marriage is actually legit. However, if your marriage is already 2 years at the time your green card is approved, you get 10 years straight. Now, another category of people who get 2 years green card are the investors. If you tell the American government or you tell immigration that you are coming in to the US to invest your money, let's say you want to invest 800,000 through the regional center, or you want to invest 900,000 or 1 million, as the case may be, on your own. Now, at the time, usually 99% of the time, at the time the petition is filed, everything that the investor is saying is based on projection. I'm going to do this. I'm going to do that. My investment is going to employ this. My investment is going to create X amount of jobs. My investment is going to do this. My investment is going to do that. Everything is based on promise. Is based on projection. They cannot verify any U.S. employment created at the time the petition is being filed. So that is why they put that 2-year condition. Okay, we are going to give you the benefit of the doubt. Have the 2-year green card, come back in 2 years, let us see, come and show to us that you actually created the employment you told us you are going to create, or you actually invested the amount that you claim you are going to invest. You actually did everything you told us in your business plan that you are going to do. So it is usually when immigration believe that they don't have that confidence that you are going to do what you claim you are doing, that is when they impose 2-year green card and then require the applicant to apply to remove that condition in order to get the 10-year green card. Keep the questions coming. Keep the questions coming. Keep the questions coming. Today we are discussing family-based adjustment of status. This program is every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. Every Wednesday. And it is free of charge. You can subscribe to our channel so that when we go live, you get notification that we are live. Today, we are discussing family-based adjustments of status. By God's grace, next week, we'll be discussing employment-based adjustment of status. So we have been answering questions relating to family-based adjustment of status. If you have questions, keep them coming. You can text your question live. You can also call in. If you are going to call in, the number to call is 817-983-4499. 817-983-4499. That is the number to call. Keep the questions coming. So, you can call us live. You can send your questions live. You can also send your question through our WhatsApp. This program is every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. Today, we are discussing family-based adjustment of status. Next week, by God's grace, we'll be discussing employment-based adjustment of status. Okay, we have a new question. How long does it take to get your green card once VAWA has been approved? Well, this is not a straightforward question. One thing I've said repeatedly on this program, and I'm going to repeat again, is that immigration is not a one-cap-fits-all. It's not mathematics. It is not 2 times 2 where you get 4. Immigration is what we call on a case-by-case basis. Every case is different. There are no 2 cases that are the same. You can have someone whose VAWA has been approved and then the green card is approved within 60 days. You can also have someone whose VAWA has been approved and the green card may not be approved in 2 years. So immigration is not a one-cap-fits-all. There are several factors that determines when a green card is approved. One of them is background check. Every single individual have different backgrounds, and no one can get green card approved in the United States without going through a background check. So they may run someone's background and then the background can clear right away. They may run someone's background and then a red flag can show up in the background. Red flag means look more closely, investigate further, something is not right. Let me give you an instance. In this office, we once represent a client who obtained green card through visa lottery. After 5 years, we applied for his citizenship. He was married, so we applied for both husband and wife. Within 90 days, both of them were invited for interview. The wife's interview went ahead and the citizenship was approved immediately. Within a week thereafter, she was sworn in and she became a U.S. citizen. The husband's interview for citizenship was rescheduled. And after that, we received about 3 additional interview notices. Every time the interview will be rescheduled. We kept on calling, we kept on writing, we kept on doing service requests, we kept on putting pressure on immigration. This citizenship case lasted for more than 2 years after the wife already became a U.S. citizen. At a stage, we decided to file a lawsuit against immigration. We needed to know what exactly is going on. We filed what is called mandamus against immigration, that they needed to adjudicate the petition. Long story short, at the end of the day, we found out that this client worked with one particular employer when he was in school. Legally, not unlawfully. He was in school at the time. Before he won the lottery, he was in school and he applied for optional practical training, OPT, which was approved. So he worked with this employer. While he was working with the employer, he got another job, a better job, and he resigned from that employer. The employer was bitter because the employer believed that the guy was really very useful to the employer. So the employer was bitter, and the employer sent a petition to the authorities claiming that the guy has a link to terrorist organization. Of course, the government received the petition and they conducted the investigation. So, while all this was going on, we were applying for citizenship. One thing, the writer of this question, one thing you need to know, and everybody listening as well, is that once an issue has been raised about someone's background, immigration cannot approve anything at all, until after the investigation is completed. There is no green card that can be approved until background clears. So, This alleged terrorist connection triggered investigation in this client's case. And the investigation lasted for years. Of course, immigration could not tell us why they couldn't complete the processing. They couldn't tell us, so they just kept on rescheduling his interview. But at the end of the day, investigation was completed, and they found out that the employer lied against him. And guess what? That employer was charged. He was charged with a criminal offense because it's a crime to make a false accusation. It's a crime. So the employer was charged with a crime. My client was eventually cleared, and he eventually got his citizenship. But he did not become a citizen until after 3 years after his own wife, who was a beneficiary of his own application. The wife became a U.S. citizen 3 years. Meanwhile, the wife was just a beneficiary of his own application, and he did not become a citizen until 3 years after the wife. So, the point I'm making here is that there are no two cases that are the same. Every single case is different. So, somebody can get a VAWA approved today and get the green card within the next 60 days. Somebody can get a VAWA approved today and not get the green card in the next 2 years. So, it is not a one-cap-fits-all. Having said that, if there are no issues in the background, usually within 6 months after VAWA is approved, usually 6 months to 10 months, the person should get the green card or should be invited for interview. Now, the next question. I got an invitation for naturalization and also got an extension for my removal of condition at the same time. Please advise what to do. This is a very straightforward thing. You don't need to do anything. Just prepare for your citizenship interview, your naturalization interview, as well as the removal of condition. Prepare for both. What this means is that since your removal of condition has not been approved, it means that you and your spouse will have to attend your naturalization interview. Usually, on the day of the naturalization interview, your removal of condition will be adjudicated first. And once approved, your citizenship will also be adjudicated same day. And if that one is approved, then you get your swearing-in notice and you become a U.S. citizen. So it's not a difficult situation. Keep the questions coming in. Keep the questions coming in. Today we are discussing family-based adjustment. Next week, by God's grace, we'll be discussing employment-based adjustment. This program is 12 p.m. Dallas time every Wednesday. That is 12 p.m. Central Standard Time. Every Wednesday, 12 p.m. Central Standard Time. And it is free of charge. Ask all the questions you have. Ask all your immigration questions. We are doing this to provide information to people. It is not for any financial gain. It is just to provide information to people, because we realize that a lot of people get into problem, get into trouble by committing avoidable mistakes, avoidable errors. So that is why we have decided to launch this podcast. Please join us every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. You can send questions in live. You can also send your question through WhatsApp. You can also call in directly through WhatsApp. If you choose to call in directly or send question through WhatsApp, the number to call is 817-983-4499. 817-983-4499. We have a new question. If someone got intent to deny and he has replied them through his lawyer, is there any letter from them that they received it? No. Usually, when you respond to notice of intent to intent to deny, when you respond to it, immigration does not send any letter. However, they do update their status online to show that they received your response. They do update their record, but they don't send any letter to the lawyer or to the client. The only thing they will do is to acknowledge on their status online that we received your response to the notice of intent to deny on so date. And usually, most lawyers, to the best of my knowledge, most lawyers also send in a response with trackable form of delivery, so that even if they don't respond, even if immigration has not acknowledged it, once the document is received, the lawyer will know, because usually most lawyers uses trackable form of delivery, so that you know that they have received the response. But they don't write any letter to respond to tell you that they receive it. The only thing they do is to acknowledge it online, but not even in all cases, but they do it most of the time. So keep the questions coming. We have about 30 more minutes to go. Keep the questions coming. Today we are discussing family-based adjustment of status. Next week, by God's grace, we'll be discussing employment-based adjustment of status. Keep all your questions coming. This program is every Wednesday, 12 p.m. Dallas time. That is Central Standard Time. It is free of charge. Tell your family and friends to join us every Wednesday. You can also subscribe to our channel so that you are notified once we go live. It is every Wednesday. So let's take a short break. I need to drink some water. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work. Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I announced, okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work. Because like I told you, I'm like a member of this family. And call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would.
Welcome back. This is Dr. Olu Asekun here. This is our live podcast. Join us every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. It is free of charge. Here we answer all immigration questions. Join us every Wednesday. Send in your question. Keep the questions coming in. Keep your questions coming in. Today we are discussing family-based adjustment of status. Family-based adjustment of status. So if you have questions, keep the questions coming in. Keep the questions coming in. We are discussing family-based adjustment of status today. Keep the questions coming in. The program is every Wednesday, 12 p.m. Central Standard Time. Every Wednesday, 12 p.m. Central Standard Time. Keep the questions coming in. Okay. There's another question. What can someone do after losing his or her green card for being out of the country for too long? Well, it depends on the peculiar situation. Talking about being out of the country for too long, you may still be able to come in if the green card is not expired, but you have to show that you do not have the intent to abandon your permanent residency. Usually, if a green card holder stay out of the country for more than 1 year, there is a presumption that the person abandoned the green card. So in order to rebut that presumption, you have to show that, one, you did not intend to abandon the green card. One of the ways to show that is by showing that maybe you continue to file your tax return, maybe you have your family who are still here, maybe you have some legitimate reason to stay out of the country for that long, maybe for sickness, for example, or maybe you have a property here, you have your house here, and your family members are living in the house, showing that you do not intend to abandon your permanent residency. Having said that, if you intend to stay out of the US for more than 1 year, the right thing to do is to apply for what is called travel document. This gives you the opportunity to stay out of the US for up to 2 years without losing your green card. That is the best thing to do if you intend to stay out of the country for a prolonged period of time. Another question: can someone with an approved VAWA petition have the approval rescinded? For example, if a woman has an approved VAWA and her new boyfriend impregnated her and she has the baby. This is a two-in-one question, but I will go ahead and answer it. The first part: can someone with an approved VAWA petition have the approval rescinded? Yes. An approval, any approval for that matter, not only VAWA, any approval, including green card can be rescinded. Every immigration approval can be rescinded. Even citizenship in limited circumstances can be rescinded. There is nothing that can be given that cannot be rescinded under U.S. immigration law. However, each one of them have different requirements, but one major denomination in the requirement is fraud. Right from any application up to citizenship, if immigration can show that this approval was obtained by fraud in the first place, yes, it can be rescinded. Citizenship, the only time citizenship can be revoked in the United States is if immigration can prove that the citizenship was obtained by fraud in the first place. That is the only time it can be revoked. However, the process for revocation of citizenship is not by immigration, unlike other types of immigration benefit. Once somebody has become a U.S. citizen, for it to be revoked, even if it is based on fraud, they will have to involve the United States District Court. In other words, such a person must be charged to court and must have been convicted of fraud before immigration can now commence revocation or rescission proceedings against such a person. But as far as VAWA is concerned, coming back to this question, that can be done by immigration. If immigration determine that VAWA was obtained by fraud, yes, it can be rescinded. However, going to the B part of the question, the reason for rescinding a VAWA approval cannot be because your boyfriend impregnated you. No. A VAWA approval cannot be rescinded because somebody impregnated you or because you have a baby. That is not a ground for rescission. The only ground for rescission in this case is if they can determine that it was obtained by fraud. Okay, maybe the impregnation by your boyfriend, maybe that could trigger questions regarding the validity of your marriage to the abuser in the first place. Yes, if it is linked, yes, that may be a problem, but it cannot be rescinded simply because you have a baby. No, that is not the question. Then in this situation, can the approval be rescinded? I believe it's the same question and I believe I already answered it. Yes, approval can be rescinded if it is determined that the approval was obtained by fraud in the first place. An approval cannot be rescinded simply because somebody have a baby. An approval cannot be rescinded simply because somebody has a boyfriend. No, that cannot be the reason. The only reason will have to be that the VAWA was obtained by fraud in the first place. So keep the questions coming. Keep the questions coming. We have about 15 more minutes to go. Keep the questions coming. Today we are discussing family-based adjustment of status. This program is every Wednesday, 12 p.m. Central Standard Time. By God's grace, next week we'll be discussing employment-based adjustment of status. But for today, we are discussing family-based adjustment of status. So this program is every Wednesday, 12 p.m. Central Standard Time. Keep the questions coming. It is free of charge. Let your family and friends know there is no strings attached. We are not doing this for money. We are doing it to provide information to guide people so that they don't continue to make avoidable mistakes or avoidable errors. That is the sole purpose. We continue to see from experience, day in, day out, little mistakes that get people into trouble. So we are providing this information in order to help people avoid this type of errors or mistakes. So we are discussing today family-based adjustment of status. So if you have questions, keep them coming. We have about 12 more minutes to go. We are willing to answer any questions you may have. Keep the questions coming. Keep the questions coming. Keep the questions coming. This is going to be every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. You can call in live, 817-983-4499. You can send in your question live. We will receive it and we will answer it. You can also send in your question through our WhatsApp. The number is 817-983-4499. You can also call in live to ask your questions. You can call the same number on WhatsApp, 817-983-4499. We'll be willing to answer your question. It is free of charge. There is no strings attached. Okay, I think we have another question. My I-130 was approved 2 years ago, and since then, waiting for my 485 interview. This is a little strange, but this is not normal. Okay, maybe I need more clarification. So does it mean that the I-130 was filed separately? Because usually when an I-130 and 485, the application for green card, when they are filed concurrently, usually the interviews are conducted same day. So usually if the I-130 is subsequently approved, the I-485 will be approved without an interview, except there are issues with the applicant background. Usually, if there are no issues with the background, there is no separate interview for the I-485. However, if the I-130 was filed and approved separately, and then the I-485 was filed subsequently, yes, there will be a separate I-485 interview. Yes, that may be, that can happen. So, but 2 weeks ago, I got a letter to do medical and update my document, which I did and send it back to them. What should I expect next? Again, these questions still go back to whether they were filed separately or they were filed concurrently. If they were filed separately, you can still be invited for interview. If they were filed concurrently, you may be approved without an interview. Okay, I think there's additional clarification. They were filed separately after removing asylum. Okay, if this was based on asylum, two things can happen. You may be invited for the I-485 interview, but if there is no issue with your background, the green card could be approved without an interview because this is based on asylum. It's not based on marriage. Usually, when an application is based on marriage, because the immigration has a responsibility to make a determination that the marriage is legit, interview is usually mandatory in such situation. But in a situation where this application for green card is based on asylum, it can be approved without an interview. If you have done your biometrics and there is no issue with your background, you should be getting your green card in the mail without an interview. You should be getting your green card in the mail without an interview if there is no issue with your background. Keep the questions coming. We have about 10 more minutes to go. Keep your questions coming. Keep the questions coming. We have about 10 more minutes to go. Keep the questions coming. Today we are discussing family-based adjustment of status. Next week, by God's grace, we'll be discussing employment-based adjustment of status. So this program is every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. So keep your questions coming. There's no strings attached. There's no consultation fee. It is free of charge. Keep the questions coming, and we'll be willing to answer all your immigration questions. 12 p.m. Central Standard Time every Wednesday. Join us. Invite your friends. Invite families. It is free of charge. There is no strings attached. This is to provide information and prevent people from continuing to commit avoidable errors, avoidable mistakes. That is the sole purpose. Keep your questions coming. Every Wednesday, 12 p.m. Central Standard Time, 12 p.m. Dallas time, join us live. This is Dr. Olu Asekun here. Keep your questions coming, and we are willing to answer the questions. We have a few more minutes, but we are willing to answer any additional questions you may have. Keep the questions coming. Keep the questions coming. Keep the questions coming. Keep the questions coming. Keep your questions coming. You can send in your question live. You can also text your question to us on our WhatsApp number, which is 817-983-4499. You can also call in live. The number to call, 817-983-4499. You can call us direct. You can also call us on WhatsApp, 817-983-4499. You can also send in your question on WhatsApp. You can as well send in your question to us live through this medium. Keep your questions coming. We have a few more minutes to round up today. We started this from 12, and it's going to be 12 p.m. Central Standard Time every Wednesday, and it is free of charge. Today, we are discussing family-based adjustment of status. By next week, we'll be discussing employment-based adjustment of status by God's grace. So keep the questions coming. Tell your family and friends it is free of charge, no strings attached, no consultation fee, no hidden fee, there's no strings attached. It is purely informational. It is just to provide information to guide people so that they avoid mistakes. Keep the questions coming in. We have a few more minutes to go today. We still have the opportunity to answer all the questions you may have. Type in your questions and send them in, or call directly 817-983-4499, or send in questions through WhatsApp. Keep the questions coming in. Today, we are discussing family-based adjustment of status. So, while waiting for additional question, let me present what I call closing arguments. Since we are discussing family-based adjustment of status, at the beginning, we explained that the way immigration law defines family is different from the way English dictionary defines a family. For immigration purpose, family of a U.S. citizen includes the parents of a U.S. citizen, spouses, that is husband or wife of a U.S. citizen, children under 21 of a U.S. citizen. That is what is defined as family under immigration law. Anything outside of that is considered extended family. So your own biological children who are 21 years and above, they are considered extended family for immigration purpose. Your siblings, they are considered extended family for immigration purpose. Your grandparents, they are not even recognized by immigration law as part of your family. Married children, they are considered extended family for immigration purpose. Unmarried children over 21, they are considered extended family for immigration purpose. So, that is what we are discussing today. Adjustment of status based on family relationship. For extended family members, there are limitations because there are numerical limits to the number of green cards that immigration can approve annually. For immediate family, there are no such limits. For extended family, there are other limits which are not available in the case of immediate family. For example, if an applicant is required to apply for a waiver, waiver can only be granted if you have immediate family as your qualifying relative. If you have your parents or a spouse or minor children who are U.S. citizens or permanent resident, that is when they can be qualifying relative for the purpose of applying for a waiver. All this is not available in the case of extended family members. These are only possible for immediate family members. So, today we have discussed family-based adjustment of status. Next week, by God's grace, we'll be discussing employment-based adjustment of status. So if you have questions relating to employment-based adjustment of status, you can send them ahead of time to our number 817-983-4499. 817-983-4499. If you have questions relating to employment-based adjustment of status, you can send it in ahead of time. You can also wait until Wednesday next week, 12 p.m. Dallas time. That is when we'll be discussing employment-based adjustment of status. 12 p.m. Central Standard Time. That is Dallas time. That is when we'll be having this program again next week by God's grace. So, before we round up, let me check if there are new questions. Okay. There are no additional questions. Since there are no additional questions, we are going to round up today for today's episode. Thank you again for watching. Tell your friends, tell your family members to join us next week, 12 p.m. Central Standard Time. That is Dallas time. We'll be having this. It's free of charge. We'll be answering all immigration questions you may have. Thank you for joining us this week. God bless you.